Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the latest episode of our Smarter Lawcast podcast. My name is Laura Hanrahan, partner in our private clients team at Hall & Wilcox, and I'm delighted to be your host for this episode, which is a follow-on from our first podcast regarding informal wills with barrister Karen Gaston. Today, I'm joined by McLean Ediger, partner in our private clients team, and today we're discussing what happens when the informal will doesn't get up. So McLean, what actually happens if an applicant is unsuccessful in having a document admitted to probate as an informal will?
Hi Laura, and thank you for having me on the podcast today. I think the first thing to keep in mind is that it's not black and white as to what the outcome can be. So there's various different outcomes that can occur if an informal will is not considered to be an informal will. So generally, the law around the country allows an informal will to either operate partially or wholly. It can act as a codicil to the will, to a prior will, and it can also operate to revoke a prior will either partially or wholly. So if we talk that through, if there is an earlier will that has been drafted and it meets obviously all the formal requirements of a will, and an informal will, a subsequent informal will is applied for and does not succeed to be proven by the court, then the earlier will stand as the last will of the deceased, and that'll be put through to probate without really any contest. But if there is no earlier will and the subsequent document that has been attempted to be approved as an informal will does not succeed, then the deceased will be deemed to have died what we call intestate. And intestacy laws are unique beast, very arbitrary, and it's important to note that there's a different statute between states which dictates how the estate will be dealt with.
Great. So that really highlights to me the importance of everybody out there making sure that they not only have a valid will, but also that at various stages in life that they review that and make sure that it is up to date and appropriate in relation to their current circumstances.
Yes,
so that
certainly.
You don't have the situation of a 30-year-old will applying that is potentially very out of date.
We could probably do 10 podcasts on the reasons why you should have both a properly drafted will, but also update it as time goes on.
Absolutely. And you mentioned there that if the deceased didn't have a will and the document is not successful as being found to be an informal will, then the result is an intestacy.
Yes.
And you mentioned that the intestacy laws are different around the country. Can you expand on what those differences mean? And
sure.
Also, is it the case that there can be a partial intestacy or a full intestacy, and how does that operate?
Yeah, so the intestacy laws, as I said, are different in each state. It's based on statute. Some of the statutes are very old. If I look in the Western Australian jurisdiction, the Administration Act is the act that dictates and confirms the intestacy provisions. I mean, that act was drafted in 1903, hasn't been updated much since that time. It was updated recently, but the intestacy provisions dictate how the estate has to be distributed, and it's effectively only to bloodline. There's this idea out there that if you don't have a formal will, that it goes to the Crown. That is very unusual. Basically, you almost would have to have no bloodline left for that to occur. In fact, we've got a matter at the moment in Perth where we think that might be the case. So we may have to apply to the court for what they call an escheatment order. But that is, we think, the first published decision ever for such an order. So it's very unusual. But what it does mean is that it imposes on the administrator of the estate the way in which the estate has to be distributed. It clearly doesn't factor into account the deceased's intentions. The wording of the informal will, even though it didn't succeed, doesn't really have any weight in that regard. It's an outcome that can really result in adverse consequences for the family members. Also, as I said, the beneficiaries under intestacy are only bloodline. So if there's any other beneficiaries out there, charities, friends, they're not going to be included. And yeah, so each state has its own intestacy laws. So for example, in New South Wales, generally it's the spouse who gets the entire estate. In Western Australia, that's different. What we can sometimes see with informal will or just wills itself is that the wording of clauses, so you might have a will that's considered to be valid, but there are clauses within the will which on their face aren't sufficiently clear or effective in attempting to dispose of the assets as they seem to be trying to. And in a case where the court, and courts will generally avoid intestacy, I mean, they will often try and construe the terms of a will they'll obviously look at the wording and they're very strict on that. But if the outcome, if they do construct the clause as having failed, is intestacy, they will try and avoid that to the extent that they can. But they're obviously not going to dispose of the assets in a way that isn't consistent or as per the wording of the will. So what we sometimes see is if these clauses don't have or aren't capable of being interpreted by the court to give effect to what the intention is or what their terms are, then we actually have what they call partial intestacy. So you may have a will that certain terms that deal with certain assets are effective, and therefore the beneficiaries mentioned in those clauses will obviously receive the assets. But if there are other assets that the will tries to dispose of in a particular way and the clauses are uncertain and not deemed by the court not to be effective, then if there's not a sort of catch-all clause that would then bequeath those assets according to that clause, you actually might have some of the assets of the estate and some aspects of the estate, some aspect of the will rather, that is dealt with on intestacy. So you have this kind of strange situation where some of the will has effect, but some does not.
Excellent. Very interesting, but sounds like it can be very complicated.
It certainly can.
To add to the complications, if we have an informal will that has failed and therefore its terms aren't considered by the court to be valid and effective, are there any other recourses that those beneficiaries who may have received under the informal will, is there any other recourse that they might have?
It's an interesting question. I mean, first and foremost, they're obviously trying to prove the informal will. So that's generally why you have these informal will disputes, is because the beneficiaries under that informal will are very aware of what the outcome looks like for them if that informal will fails. So it may well be that they aren't well provided for or don't receive provision under an earlier will, or it may well be that if there's an intestacy, because there is no earlier will, that beneficiary doesn't receive anything. They're generally very well aware of what sort of the other alternatives they have to bring claims. That's generally why they prove the informal will. But as to whether there's other types of recourse, it really depends on the relationship of the beneficiary to the deceased. If it is a type of person or a charity or some sort of organisation who is, as I said, not bloodline, they obviously won't be provided for under intestacy. Now, obviously, there's a few avenues they have. Each state has its own adequate provision laws. They're called TFM claims in New South Wales and Part 4 claims in Victoria. Now, that allows somebody who hasn't been adequately and properly provided for in a will to bring a claim saying that they should seek provision, and they effectively seek the court's involvement to vary the will. But the problem with that is that there's only certain types of categories of applicants that can bring those claims. And generally the sorts of people who aren't provided for in intestacy also don't have standing to bring those claims. So that can be an issue. Another sort of avenue of recourse, if there's partial intestacy or partial ineffectiveness of an informal will, is to try and rectify the will. But in the absence of clear evidence as to what the testator intended, say from a file note, had the deceased gone to a lawyer, it's quite hard to succeed with those claims. So really, it does leave you with little recourse, because the people who are often the most disappointed from informal will claims not succeeding are the types of, or a certain category of beneficiaries who aren't provided for under the relevant FPA laws as having standing to bring a claim.
Sounds like very unfortunate circumstances for those disappointed beneficiaries. And again, reiterates that point that we made at the very beginning, that will makers need to be reducing the risk of informal will applications by making sure that they have a properly documented and valid and effective will that is updated for their current circumstances.
And sorry, I should just say as well, there seems to be an assumption out there in the community that if I don't have a will done and I just write some notes down, or I've got a draft piece of paper or whatever it might be, that because I haven't had a will done by a lawyer, of course the court's going to interpret what I've written down on that piece of paper as being my last will and testament. And look, despite what I said earlier about, yes, the courts will try and construe the terms of wills in a broad way to avoid, or there's almost a presumption against intestacy. The reality is, and obviously you spoke about this with Karen, these informal will claims are hard to succeed with. So people shouldn't just rely on the fact they haven't got a valid will as meaning that I've just got a piece of paper, so the court will say this is all we have that would somewhat express his testamentary intentions, so of course it's going to succeed. It is a high threshold to succeed, and to prove that that a testator adopted a document as their last will and testament despite not going to see a lawyer and getting it done properly is difficult. And most of the cases that succeed, these are done in contemplation of death.
And that leads really nicely into thinking about we've seen a number of wills now that where a grant of probate has been issued, where wills have been prepared as an iPhone note or in some other digital form. And so can you just have a think for us about, or tell us about, what the biggest risks are if we're going to be moving digitally? What are the biggest risks involved if will makers are relying on notes on iPhones rather than going to see a lawyer and having a properly prepared will done?
The starting point is that almost all states, I think all states, for the formal requirements for a will to be valid, you always have to have it signed properly and witnessed. Now, the courts there's very broad application of what a signature is. It can be a mark or what have you, or somebody can sign it on your behalf. But if you've drafted something on an iPhone, it's going to be considered to be a document. That's fine. But the biggest issue is it's almost never going to be able to be formal because you haven't signed it and it hasn't been witnessed. A handwritten note, you can obviously overcome that issue by having somebody witness it. But yeah, if we're moving into the sort of more technologically advanced digital age, the law is still expecting from a formal, non-contentious, common form proceeding that it's a piece of paper that has been properly drafted and has been properly signed and witnessed. And the law hasn't changed in that regard. That's the easy way. And as much as it might seem like an upfront cost that people don't want to pay to get that done properly, that cost compared to the cost if you have to prove an informal will is minimal. In terms of iPhones and things like that, if you're using language that clearly explains that you intend this to be your will, would have a huge amount of impact on a judge. And the court would very much take that into account and look at the circumstances in which the will was drafted. But there's really no foolproof way to draft a will that's going to get through as an informal will. The courts will look at when it was drafted, the circumstances and the conduct of the testator in effectively adopting that document as a testamentary instrument and their last will. Look, there's just no better way to deal with it than having a professional who knows what they're doing draft the will. And as I said, I just can't emphasize enough that the upfront cost of having it done is minimal and pales into comparison compared to the cost to litigate.
Absolutely agreed. Thank you so much for joining me today, McLean. Thanks everybody for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe wherever you get your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.